operators.
Counsel, I'm interested in the limitation to a foreign battlefield. Does that mean, for example, there are bases where we're operating from in Afghanistan at the same time that would not be in a foreign battlefield because it's not as directly engaged as Bagram was in this case?
Well, the rule that we're asking for would talk about whether there are combatant activities, and we're using the exception in the FTCA as a model. Just as the court did in Boyle, it used a different exception. It was looking at general procurement contracting, and so it was looking at the discretionary function exception. But I think that I would say that most everything that the government was doing, that the U.S. military was doing in Afghanistan in 2016, was likely very closely connected with combat activities. And there's no doubt that respondents' activities at Bagram were supporting the military's combatant activities. And so the E. coli in the lettuce that the troops are eating before they go out on patrols, outside the wire in Bagram, that is arising from combatant activities.
Oh, and what
so
if the
this
E. coli infection takes place, 700 miles away in a base that is supporting the activities at Bagram?
I think that that's going to be a question about what it means to arise from the military's combatant activities. We also have the second prong, which is about, and just to finish the answer to the first prong, that can certainly extend to people who are supplying the troops, who are on the very front lines. The Johnson decision that my friend referenced from the Ninth Circuit shortly after the FTCA was first enacted recognized that, ferrying ammunition to the troops is something that just helping somebody get ready to wield combat is a combatant activity. And here the question, by analogy, is also whether the contractor was performing within the scope of its contract. And if it was...
Okay, so ferrying the troops, what about preparing the rations and food that is going to eventually be used at Bagram? And there's some, infection at the food plant in, some place in the United States.
Yeah, I think that... I'm not sure how the combatant activities exception in the FTCA has been construed in a context like that. I think that for preemption purposes here, this goes to a question that Justice Barrett just asked, whether this really needs to be overseas. I think for overseas, it's overdetermined that the federal government's interests are at their height and the state's interests are at their lowest, and therefore it's easiest to say when it's an overseas situation, and it's that the E. coli is happening in Afghanistan, then that's where the claim is arising. It's arising from the military's combatant activities there.
So help me, Mr.